to the podcast, HOA Hell. I'm your host, Michael Kushner. With me today is Senior Associate Attorney at MBK Chapman, Sam Kill. Sam, welcome back.
Thank you, Mike. Good to be with you.
Well, I feel like we've done this a few times. Just to bring everybody up to speed, this is the sixth and final episode of our six-part series on neighbor disputes and HOAs. To refresh everybody's recollection, in the first episode of our series, we talked about private nuisance and specifically noise, light pollution, and we talked about rights and remedies. In the second episode, we talked about damage caused by trees and roots and what remedies would be available and what kind of damages occur and how to best prepare yourself to be compensated.
Right.
In the third episode, we ratcheted things up and talked about what? Refresh my
boundary disputes.
Boundary disputes.
Yeah.
So we included, we talked about things like trespass. We talked about spite fences. We talked about adverse possession and prescriptive easements.
Right.
In the next episode, we talked about what happens when it's the HOA that's the problem, when they aren't doing one of their fundamental jobs, which is to enforce governing documents, which often require them to intercede on behalf of homeowners, even though it might be a neighbor-to-neighbor dispute. In the fifth episode, we ratcheted things up emotionally, and we talked about some serious things like assault and battery, racial discrimination, harassment, things like that.
Right.
And today, the sixth and final episode, it's kind of the catch-all episode.
Yeah.
We're talking about some, and these aren't unimportant, and they aren't less important than anything else. They just don't quite fit into any of the buckets that we've filled so far.
Much more nuanced.
Right. And these are, in fact, a couple of these are among the most common causes of action we ever bring on behalf of our clients. So we're going to talk today about things like negligence, declaratory relief. We're going to talk about, well, you know what, let's get right to that.
Okay.
What we're going to cover today is why negligence. I got my notes here because I want to make sure I hit those.
Okay.
Why negligence is often one of the most flexible and underused claims, but why our firm in particular utilizes it to great effect, a negligence claim or cause of action. What waste is when it comes to property. There's intentional and negligent waste, what that really is and how it's kind of defined legally. We talk about conversion and how that's different from the crime stealing or theft, okay? We talk about the brutally high standard, we're going to spend some time on this, related to intentional infliction of emotional distress, because probably the most common thing that we hear clients say they want compensation for, and they use these words, my emotional distress.
Right.
But the way people use that term and what it really means in the law are completely opposite each other. So we're going to talk about, in the HOA context, how incredibly difficult it is to have a claim that survives.
Great.
That's an IIED, which is intentional infliction of emotional distress. And then we're going to talk about dog bites and how it's strict liability, and we're going to define what strict liability means. And then we're going to talk about another very frequently used claim, declaratory relief, and how it's kind of a catch-all in and of itself, and it's powerful, okay? So let's jump right into probably the most common cause of action that's probably included in every lawsuit we've ever filed, and I might be exaggerating, but it is that common, and that's negligence.
Right.
Walk me through what, in the context of an HOA claim, what negligence might be, and specifically in the context of a neighbor-to-neighbor dispute.
Okay.
And then I'll give some examples. But
Sure.
Talk to me about the elements are.
So basically in California, negligence, and really beyond California, is when there's a duty or a duty of care, there's a breach of that duty, and then there's a causation element, and that's a cause of the ensuing damages. So you have damages that occurred as a result of that breach.
So what if you can prove a duty? You can prove that a breach of that duty occurred. You can prove that there's and they call it proximate cause. You can prove that the actions or inactions by the person accused of the negligence related directly to what happened to you, but you can't articulate any monetary damages. What happens?
Well, you haven't satisfied the elements of the claim.
You lose.
Right, you lose.
Right. So obviously, we when we are investigating, we are looking into meeting all of those elements. Okay?
Exactly.
So that's the great definition of negligence.
There simply has to be an injury resulting from those actions or omissions.
Right. And we talked about, briefly, negligence the other day when we were talking about it as a remedy for some of the things. I think in episode 4, we talked significantly about negligence. And one of the things we said was it's an objective standard, and you're looking at somebody who acted in a way that is contrary to what an ordinary person in that situation would do.
Right.
Okay? That's negligence. They breached a duty. So let me give you some concrete examples, because those are always easier to understand than some esoteric, ivory tower academic discussion or definition.
Sure.
Okay? So a neighbor overwaters. We've had a case like this.
Oh, yeah.
I'll talk about it in a second. A neighbor overwaters their planter box and it floods your unit. So we had a case, and we were talking in this case. We ended up settling probably a month before trial. By that time, the attorney's fees were pretty significant. Now, we had offered to get out of the case at the beginning for $5,000. In other words, pay for repairs, which was at that time maybe $35,000 in repairs for the damage that was caused, and then pay us $5,000 for attorney's fees. HOA said no. We went through ADR. None of that worked. We filed a lawsuit. Insurance got involved, but they don't really care until discovery is done. And so move along forward 8 or 9 months, our client's in tens of thousands of dollars. And we end up getting every dime of our attorney's fees back. And by then it was, pretty high. Right. And we got every dime of the repair costs, which were even higher now because materials and things had changed. It had gone up. That's just the way it is. Yeah. But basically, what happened was the lady upstairs used to just she had a whole garden up there on her balcony, and she watered all the time. And it was, and the HOA had responsibility here too, because the gutters that were supposed to catch the water going off of the porch were all either clogged or rusted or both. They were clogged and rusted. Okay. And she was overwatering and not caring about where that water went. And there wasn't a way. And part of it was her fault. Part of it wasn't. But the point is, it caused, $30,000 in damage to our client's unit. He had to pull out his entire kitchen. And
I wasn't involved in that case, but I'm assuming the HOA was aware of the issue. They were notified, and they failed to act.
They had been notified for such a long time.
Right.
And so, needless to say, they paid us every dime. Or they paid our client every dime.
Great.
The bottom line is, but that was negligent on her part, and it was negligent on the HOA's part.
Right.
Okay. Another example. Let's say I improperly store my bicycles. I clog a walkway or something, right? And I cause somebody to trip and fall.
Yeah.
Okay.
Right.
Or let's say I fail to maintain a shared balcony. Maybe I have one of those balcony that's shared with one other unit, and I'm aware that the railing is loose. I don't take care of it. Somebody gets hurt.
Right.
Okay. Or let's say I leave a sprinkler running too long and it floods somebody else's unit, right? Or let's say I'm negligent in my regrading of my backyard and I cause water flow. Well, there's trespass there. We talked about that at another episode, but that's also negligence.
In all those cases that you just listed, foreseeable that those injuries and damages would possibly
If you
occur.
change the grading such that water flows from your property instead of draining on your property, you're supposed to have drains. If it flows out of your property into your neighbor's property, it's extremely foreseeable that you're going to cause some issues. And those issues are pretty foreseeable too.
Right.
So, and it's going to lead to damages, repair costs,
exactly.
damage to their property.
Yeah.
I leave construction debris somewhere and a kid gets hurt. Okay, it's a nice pile of things to play on. It's an attractive nuisance, right?
Yeah.
So look what happens. So those are examples of negligent conduct, and there are millions of examples. As good as your imagination is, you could come up with that many different forms of negligence. So I can't possibly name them all, but we see it every day. Okay, especially in a multi-unit situation like a townhome or a condo, because you're closer to everybody, and you have more shared elements.
Right.
The fewer shared elements there are, the fewer opportunities there might be for somebody to be negligent about your property. If you live in a single-family home neighborhood, and you've got a nice big lot, and you're kind of separated from your neighbors, damage to your house is going to be very hard for somebody else to be effectuating.
Right.
Okay. But when you live in close proximity, well, it's much easier. So you see negligence more so in multifamily housing than you do in others, but you see it everywhere.
Right.
Okay.
Exactly.
So that's negligence. Anything on that you want to add? I think we covered it.
No. It's quite a bit that we covered.
Okay.
Yeah.
Now, next is something that I would say is not so common. It's actually pretty rare. We don't use this cause of action frequently at all. Okay. And that is something called waste.
Yeah.
Waste is, when it's applicable, is a great tool to use. But it's often handled effectively via other claims, and so it's not always necessary to bring a waste claim. You can usually use trespass, and you can usually use negligence or both. And you don't always have to have waste. Waste gives you a little bit extra something. We'll talk about that in a minute. But it's there if you need it. And basically, here's what it is. It's when somebody damages, okay, or devalues your property in some intentional way. Now, there is negligent waste, but that's different, okay? We're not going to talk about that. So let's say, for example, the co-owner rips out landscaping without consent. Let's say we have one of those, we have a couple of these in our neighborhood where, for whatever reason, even though they're single-family homes, two of those homes share a driveway, and then they diverge.
Right.
So that first 50 feet is a shared driveway. Yeah. Let's say homeowner number one goes in there with a jackhammer, starts destroying it and changing things, or takes part of it out and then makes it a dirt road. I don't know. I mean, just something dumb. But that would be a form of waste.
It would be.
Okay, it wouldn't be trespass because he has a right to be there.
Right.
Okay, but it would be a form of waste. All right. Another example is someone intentionally allows a shared roof to deteriorate. Okay, in some, and this isn't common either. Again, this is why this is pretty uncommon. But in some communities that have townhomes, let's say two sets of townhomes, like a duplex, have their own roof. Yeah. The HOA might not be responsible for the roof. They might be co-owners of the roof and responsible for that roof, the two of them. So let's say somebody refuses or goes up there and screws around up there and damages the roof. That could be waste. Right. The reason it's rare is because it's an older cause of action in California, and it's been subsumed by newer ones, or it's been subsumed by case law that in expanding other ones. So, for example, negligence has become so ubiquitous that it kind of subsumes the entire need.
It's really the more dominant cause of action.
So we don't really use it anymore, but I wanted to mention it. And I'm not going to say anything else about it because, again, it's pretty rare. Right. The next one is conversion. This one we use all the time. Conversion, simply put, is legal stealing. Right? Yeah. It's the non-criminal version of stealing. If I break into your home or I sneak into your backyard and I steal your kid's bike, I've committed a crime. Okay? The police can be called. I can go to jail. That's theft, right? But I've also converted. Right. You can sue me civilly for that. So when the police get involved, it's the people of the state of California versus you. Okay? When it's a crime, it's not your neighbor versus you. It's the state of California versus you. A civil case is a private citizen versus a private citizen, or a citizen versus the government, or the government versus a citizen in a civil way, non-criminal. So I can be guilty of a crime and conversion, and you're entitled to damages for conversion. So I'll give you an example of some conversion claims in an HOA case, if you can. I'm putting you on the spot, but...
Sure. I mean, tools, when you wrongfully take tools.
We see that.
You mentioned bikes, toys. Another one that comes up is packages.
Right. Porch pirate type things.
Right. I mean, that's a common one these days, notwithstanding people having their Ring cameras, et cetera.
Which is why it's important to have that.
Right. I mean, really, any type of personal property that's wrongfully taken,
even money,
you deprive the use of it to the rightful owner.
That's right.
Yeah.
Even money. If you take money out, if you're invited into somebody's home, you're a guest, and you sneak into their you look at their coffee table and they got their wallet there, and you pull out $100. Right. That's conversion.
I mean, you may be lawfully on the premises, and then you cross into the wrongful
convert
conduct.
Something.
Exactly.
Right. Basically, if you're taking somebody else's personal property without permission, or if you had permission,
you refuse to give it back,
but that you refuse to give it back. Yeah. Like I lend my lawnmower to my neighbor, and then and then a week later, I'm like, hey, John, I need my lawnmower. He's like, well, that's mine now. That has now become conversion. Okay? It wasn't, but now it is.
Yeah. Unbelievable. That still happens.
It does happen. Yeah. We see conversion all the time, just in different forms. Yeah. But conversion is great. Now, one of the good things about conversion is, in addition to damages, we are also, if we can satisfy the statute, you can get punitive damages for conversion. In other words, you can get your actual damages, your real losses. Like, let's be clear, he steals a $400 bike and then destroys it, or it gets wrecked, or he sells it, right? So it's gone. You can't get the bike back. Well, it's $400. Those are your actual damages. But you can also get punitive damages in many circumstances. And punitive damages are designed specifically to punish and make an example of the perpetrator. Right. So, and that's based entirely on their net worth. So it could be punitive damages will depend on financial factors related to the defendant, but you can get that on top of your damages as well. Okay. Now, conversion can also, depending on the whether or not these CC&Rs just use the word lightly or not, could also be nuisance too. Because nuisance is sometimes defined as, if you're violating a law, it's illegal to take people's property. So you could claim nuisance. But it's its own cause of action, and it's got punies attached in some cases, okay? So yeah, you brought up tools, great one. Or refusing to return something, or straight out theft. I march into your backyard, I take something. I want that, it's mine, okay? Do call the police, but you also have a private claim as well. You know what else could be? We've seen this before. Usually, again, in multi-housing. You don't see this in single-family housing where they have private garages. But in, let's say, a garage that's assigned to you, or a unit that's assigned to you, or a space. Right. Somebody decides they call the tow company to tow your car from your space, right?
Yes, we have seen those, yeah.
That's conversion.
It is.
Okay, and it's not the tow company that's guilty of it.
Right.
Okay, it's the person that did that.
Or you wrongfully throw away people's personal property.
Yeah, I could see that.
Dispose of it.
Yeah,
I mean, that happens too. Yeah.
You decide that they're, they have a kind of maybe a chipped or cracked statue on the front lawn, and you find, that's an eyesore. Right. And instead of letting the HOA do its job and say, look, that's an eyesore, you need to remove it or get it repaired, you decide just to chuck it. You've just converted that thing, and if it turns out to be a valuable antique, well, then you're on the hook for some money. Yeah. Even plants. You cut somebody's plants because you don't like their flower garden, or you don't like that they planted something that takes a lot of water, and you're a conservationist, and you decide to rip out those water guzzling plants. You've just converted. Right. Okay. Now, if it's a tree, you've just violated the tree statute we talked about in the second episode of this series.
And then you have the punitive
damages. And then you could be up to 3 times your damages. Right. Okay. Plus punies possibly. Right. So conversion is something you want to stay away from, okay? But it's a great claim, and we use it frequently. Another one that we use sometimes when it's appropriate, but we almost always have clients demand that we use it, and we need to educate. And this is what we're going to spend some time on now is IIED, intentional infliction of emotional distress.
It's a big one, yeah.
I would say, without exception, almost every 8 out of 10 clients that come into our office, when they talk about their damages, they bring up their real damages or actual damages. It's going to cost this much to repair, or here's how much it was worth, or whatever. Here's how much I had to pay out of pocket. Those are real damages. Easy peasy to prove. That's great. But then they go into, I've lost sleep. I've lost this. I've been a wreck emotionally. I want emotional distress. I want $1 million. And I don't blame them for wanting what they want. And I don't doubt that they've suffered what they've suffered. Yeah. But the law only gives us certain remedies and certain tools, and it requires certain elements be met. So the legal definition of intentional infliction of emotional distress is very different from the colloquial definition. Yeah. Let's talk about, in particular, let's be positive. Let's be optimists for a second. Okay. Let's talk about the few types of cases where an IIED claim will actually probably survive. That is to say, it's going to pass muster. Okay. Because I'll tell you, when we do allege IIED, unless it's so obvious in the complaint that this is one of those ones that we're going to talk about in a sec that usually almost always carry with it an IIED claim, there's going to be a demur to the complaint, which means that basically they're going to challenge it on its face and say there isn't sufficient evidence alleged to support a claim for IIED. Right. And this is how we know how strict courts are with this, okay? And that is, and we've had this in a case. You weren't here at the time, but we had this. Racial discrimination would very often supports an IIED claim. So here's a case we had once. This wasn't a neighbor-to-neighbor dispute, technically, although I guess all HOA disputes are because everybody on the board actually lives in the community. Right. So technically, even if it's the HOA doing it to you, it's still neighbor-to-neighbor. So in that context, I feel okay using it. But we had a board member who didn't like African Americans. And there were notes left on our client's car. Our clients were African American. There were notes left on the car about how the neighborhood didn't want them there. So they put up a camera. And I guess word didn't get out about the camera, but we got on video, crystal clear, in high def, the HOA president leaving a note 2 days in a row. And you could see the note under the windshield wiper, and you could read the note from the camera. It was beautiful. Wow. We just zoomed in, there it was. The best evidence you could get. Talk about great documentation. Slam dunk. Okay, that supported an IIED claim. Now, believe it or not, we actually had to file suit because my client wanted what she wanted, and at ADR they wouldn't do it, and we had the insurance company there, so we said, "Great, we'll see you in court." It's settled, but we had to sue, and we sued among other things. In addition to racial discrimination statutes, we sued for IIED. It was great. Fantastic. And they didn't even try to demur because they knew they couldn't. Okay, we alleged more than enough to support a claim for IIED. Right. But racial discrimination is one of those cases where you are absolutely 100% gonna, 99% gonna be able to support a claim for IIED. Right. Okay, a neighbor deliberately sets off loud alarms or noises, like literally we've had people put speakers against the fence and blast something to trigger somebody's PTSD, let's say. Oh, okay, 100%. That's going to support IIED. You have one in mind that I didn't mention yet?
Well, a few do come to mind, but real quick, if I may. So anything that's extreme and outrageous, right? So not merely extreme and outrageous, but there's an intent or a reckless disregard, or just disregard.
And extreme and outrageous means if it shocks your conscience.
If it shocks your conscience, I mean, goes contrary to just simple human decency.
That's right.
And on its face, or when you're looking at it, assuming there's evidence of it, it's clear to most people of good conscience.
Right. And by the way, this isn't enough yet because we're going to talk about, you're going into elements. I want to do that next. We're going to go into the elements next.
Yeah, so to me...
Just give me some examples of where it's usually supported.
I mean, you mentioned the extreme combative hostile behavior such as triggering PTSD, the racial discrimination part of it, that's a very common one we get.
How about a pet one?
Yeah, so if someone threatens or actually injures or kills your pet, or threatens or actually engages in conduct that's injurious to your children, let's say.
Let's stick with pets for a minute.
Right.
Do you remember the case we had up in the, what county would you call it? In
NorCal?
The desert. No, the desert. Mojave. I just don't know what county. There's some towns in the Mojave Desert.
Oh, okay.
I just don't remember the town. We had a client there. The neighbor shot this guy's dogs from in his yard beyond the fence, through the fence, and shot the neighbor's dogs because these dogs would always aggressively bark at the gate, at the fence there, and make noise. But there was no way the dogs could get over there.
Right.
Okay? The guy shot them dead. Quintessential IIED, because guess who was watching that happen?
Yeah, the dog's owner, our client.
He was standing right there when it happened, and he lost his pets.
Right.
Both of them.
I mean,
now that guy went to jail.
Yeah.
Okay, and we got a very hefty amount of money from the insurance company. Come to think of it, I can't remember the insurance company. I don't remember whether or not they covered it. I just know we got a big judgment and we got paid, but I don't remember. It was several years ago. The point is, that was classic IIED. That when you hurt somebody's pets or children, then you're in IIED category. As long as the person that's claiming IIED was watching it happen. That's a big factor. We'll get to that in a minute. Any persistent or long-lasting threats of physical harm. Yeah. And it can be threats to your dog if it's persistent. Your dog's freaking loud. Next time I'm just going to throw some poison over the wall. And they keep saying that all the time. That could be IIED because now you're always in anguish about whether or not your dog's going to be poisoned and you don't know. And you're doing everything you can to control the dog because that's not normal. You don't do that to people. If the dog's being loud, which is hell, then you handle it through proper channels, but you don't kill the dog or threaten to kill the dog.
Exactly.
That's a terrible thing to do.
Right.
It's sociopathic, but that's IIED. Even if it's persistent threats and you don't carry through, it could be IIED.
And needless to say, that can be multiple criminal issues, right?
Could be.
But also multiple crossover civil claims, one of which is IIED.
But IIED is the one we're talking about.
Exactly.
Okay. Now, let's talk about some of the elements. IIED has to be extreme and outrageous conduct. It has to kind of shock the conscience. Now that language isn't in the statute itself, but extreme and outrageous is, or reckless disregard. Okay, the person that's suing for it has to have been present to see it. Here's an example I give when I try to explain to potential clients, people that come to consult with us, how difficult it is when they're insisting on IIED. And I use this, admittedly, it's an exaggeration, but I use it to make a point. And that is, whoever this person is, listen, person, unless you saw your HOA president or your neighbor beat your dog to death with a baseball bat, it's going to be hard to prove IIED. Now, yeah, I'm exaggerating, especially in the context of some of the examples I gave, but I say that to make a point. It is not easy. So let's talk about cases that almost never, without more, involve IIED, but which we have clients every day tell us they want. Selective enforcement. You've repeatedly asked for permission to build a fence that other neighbors have gotten, and you've been denied because they don't like you. It doesn't matter how many times they deny you. It doesn't matter how unfair it is. And it's illegal, and we have a claim. It's for selective enforcement.
Yeah.
Breach of fiduciary duty, negligence, we'll get them. Don't worry. But not IIED. You weren't going to get that. Not for selective enforcement.
Right.
Because no matter how egregious the selective enforcement is, it never rises to the level of that outrageous conduct that's really required.
Right.
Okay? Another example that we see a lot of, I want IIED, I want my damages, I was emotionally distressed, is gossip.
Oh.
Okay?
Yeah.
Somebody started a campaign against you. And let's say they haven't risen to the level of defamation, which we talked about in our last episode, right? Let's say they haven't even risen to that level. They're just saying horrible things about you, but they're like opinion type things. They aren't calling you a crook or a fraud, but they're saying, you know, he's just not fun to be around. He's a terrible person to hang out with, super boring. Just, you know, I don't know why they're here. I just wish they would leave. So none of that's defamatory or actionable,
Yeah.
but it could violate other things. Probably not, but it could. But it's certainly not going to constitute IIED. It doesn't matter how much gossip people are doing about you. It's just not going to rise.
It may cause you anguish, but it doesn't cross that threshold.
We're not
outrageous.
diminishing
Yeah.
the hurt feelings
Yeah.
and the real social anguish, especially if you're a social pariah because of what these people are doing.
Yeah.
Nobody's discounting the pain you're feeling. It's just not going to be actionable under that kind of claim.
Right.
That's all we're saying.
Yeah.
Okay. Another one is in that situation with the leaking, the overwatering of the other neighbor, and then all the water damage, and they ignored and ignored and ignored and ignored. Or somebody's causing a nuisance, and I'm begging the HOA to get involved and just, hey, enforce the governing documents. Stop this barking at midnight or 2 a.m.
Yeah.
It's not going to rise to intentional infliction. Now, if the person is putting his dog outside on purpose, so knowing that it's going to, you know, the barking's driving you crazy and keeping you up, that could. But the fact that the HOA has ignored your nuisance claims is not going to be enough to support an IIED claim.
Right.
Here's the thing about IIED. It's not enough to be on that list of things where we said it's usually involved. It takes more than that.
Yeah.
You're going to, first of all, and we tell everybody this, when they do have a claim that would support an IIED claim, when their facts would support that, we tell them, hey, keep in mind, your medical and emotional medical history is going to be open for perusal.
You're putting it at issue.
You are putting your mental health at issue. So they're going to be able to have their independent psychologist examine you. It's an independent medical examination. They're entitled to that. Your medical records, the notes that if you're in therapy, the notes that your therapist takes are going to be open to review, to determine whether or not you've suffered from depression for years, even before you moved in. They have a right to explore that. So you always go in knowing you're opening that up. But more than that, embedded in what I just said was, you're going to have to show that it's not enough to say I'm depressed or it's caused me anguish. You're going to have to show that the anguish has led to something like I'm now in therapy, or my blood pressure, you know, I used to have steady blood pressure, and now when this guy moved in, boom, it started skyrocketing. You're going to have a doctor say that in writing, okay? You're going to have to be able to show, you might be in therapy, you might be on medication. You're going to have to show that proximate causation, and it's going to have to be through medical testimony.
Right.
That's an important factor there, because if you can't prove those damages, you're not going to get anything.
Right.
Okay? There are some exceptions to that, which I won't go into. I think we've covered it. I think we've said it.
We did.
It's there, and it's real, and it's horrible, but it's rare in the context of a neighbor-to-neighbor dispute unless it rises to the appropriate level, and then we're there. But none of that diminishes what everybody that talks about what they've gone through doesn't diminish that. I'm just saying legally and colloquially are two different things. The next issue we should probably talk about is dog bites. Dog bites are easy. You've heard about you get a free bite. That's not true. Not in California. It might be true somewhere else. I don't
Right.
know. I'm not licensed elsewhere, but I'm licensed here. And that's not true. Dog bites are what we call under the law strict liability.
Yeah.
That means you just have to prove one of two things. And if you prove one of two things, they're liable. Period. That's it. Strictly liable. One of two things are the bite occurred in a public place or in a common area. That is, in a place you had a right to be. Okay? Or the bite occurs on somebody's private property where you were lawfully on that private property. I'll give you two scenarios. Scenario one for the first one. You're walking on the sidewalk in a common area in your neighborhood. Dog escapes a leash, comes up and bites your leg. Okay? You're allowed to walk in the common area. The dog wasn't controlled at the time. Dog bit you. Okay? Strict liability. Person's liable for your damages and your injuries, medical, whatever. Okay? Another second scenario, you are lawfully on private property. You are invited into your neighbor's home, and while you're there, their dog comes down and bites you.
Yeah.
Strict liability. Period. End of story. Now, what the flip side of that is what are the defenses a dog has? Well, there's two, and only two. Provocation and trespass.
Yeah.
Okay. The second one's my favorite, but let's talk about provocation. Can you give me an example of provocation?
Well, if you're approaching a dog in a threatening manner, and obviously the dog reacts to you,
If you get close, it's on a leash, but you get close enough for the leash.
Close enough, and it's not one of those simple, innocent, let me pet you or saying
That's
hello,
not provocation.
but in a way that's clearly eliciting the wrong type of reaction from the dog.
Right.
And the dog reacts. That's one of
Right.
those.
And that now the one he describes is a little bit harder defense to prove.
Yeah.
Because the other person, I guarantee you, unless it's being videotaped, the other person's going to say, "Oh, he just went to pet.
Right.
I just went to pet the dog," and the other person's going to go, "No." The one that's being accused is going to say, "No, or the guy that the dog bit is going to be, "No, you lunged at my dog, and that's why." And the other guy's going, "I just went to pet him." So yours is a harder one.
One instance we had, one example, sorry not to cut you off, but
okay.
We actually resolved this case. It was a dog bite issue favorably for our client, but this was an instance where our client actually had a witness who actually testified and provided a declaration to that effect under oath that she went, "Stop, please don't approach," and put the other guy on notice, the wrongdoer.
Please don't come near the dog because he's not a good dog.
And the accuser in this case, who was the wrongdoer, essentially disregarded those instructions.
Walk right up to the dog.
Exactly,
Right.
and caused a provocation.
And there's no way for a person to walk in their dog on a leash in control to avoid that.
Yeah.
If they say, "Please don't get close," you're supposed to ask, "Can I approach?" Or
Right.
"Can I pet your dog?" You're supposed to ask that. This person not only didn't ask, but violated a very simple instruction: "Please don't."
Yeah.
I'm training the dog. It's aggressive. I'm working through it. Don't come near. Walked right up to the dog, got bit. Well, guess what? That's provocation. But here's an even easier provocation. Your dog's in the backyard. Your neighbor goes through the fence with a stick and, through a chain link, let's say, and starts poking at the dog.
Oh.
All right? And the dog happens to get his finger when it's near the chain link. It happens to grab his finger.
Right.
It's provocation. He's not going to get a dime. There's no strict liability there. Okay? And then the more fun one is trespass. Somebody marches into your yard uninvited, and your dog happens to be out there. If he gets bitten, he gets bitten. That's it. Dogs do. That's what dogs do.
Yeah.
Okay? At least good dogs. Okay? They protect their homes and their families. That's what they do. So those are the two defenses. But outside of those defenses, it's strict liability.
Right.
So if your dog bites, you're paying. It's that simple. Okay? Now, last one, and this is one we use all the time. It's called declaratory relief. Sometimes you're not looking to recover any damages. Sometimes you need the court to declare something. Usually, it might involve a contract. Like, under this contract, it's vague and ambiguous as to what my obligations and duties are vis-a-vis this or that. And we need the court to straighten us out and tell us. That's often when we get. Or there is some sort of property line dispute, and it's having a survey isn't really being helpful, right? Or a maintenance obligation, it's really vague. We have a party wall, right? Or a line tree. To bring back episode 2 of this series, we have a line tree.
Right.
And we're not clear on kind of how we're supposed to divide and conquer. And if all else fails and you end up having to file a lawsuit, declaratory relief in that kind of claim, you would say something to the court like, we acknowledge, we have a line tree situation here, and there's a controversy, an actual controversy as to our mutual rights and obligations to each other with respect to this tree. We need the court to declare one way or another the following. Mm-hmm. That's what dec relief is. Yep. It's a great mechanism, catch-all mechanism we use all the time. When money damages aren't an issue, we need a declaration from the court. Another one, you might have a shared use balcony of some sort, and there might be some planters that were put in by the previous owners, and you're not sure who's responsible for the planters. Is it both of you, or is it just the one where the planter, favors it's over on their side of the porch, or how do we do that? That would be one. Now, I'm not saying that you necessarily want to bring a lawsuit for that, but that's the remedy that you would bring in order to solve that. Who's responsible for this? In the absence of something clear, like a clear contract, which is unambiguous, you would ask the court to kind of resolve that issue. Or, the documents talk about a view corridor, but there's a dispute as to the extent of the view corridor, and somebody's blocking a part of the view that you claim is not included in the view corridor. Mm-hmm. If the documents don't tell you, that is one that could and often does lead to litigation, because depending on what that view is, could be very significant, could be valuable. People sometimes pay millions of dollars for certain views. So if there's a dispute as to the scope or extent of a view corridor, and the documents don't really resolve that ambiguity, that just nobody ever thought of it when they were drafting, that's ripe recipe for a declaratory relief, where the court would, based on everything it looked at, would then make a decision as to whether or not that provision is covered under the view corridor, whether that view is part of that view corridor. So we use dec relief every day, and we use it to solve these catch-all or esoteric problems that are created by ambiguities, because nobody's perfect. And that's the kind of thing we do. And those are kind of like the legal afterthoughts here. Not less important, but they don't fit in any other category. I think we've exhausted them today. I think in this 6-part series we've talked about,
covered a lot of ground.
I think we've talked about almost every possible way that neighbors can hurt each other, emotionally, physically, or metaphorically.
Unfortunately, a long list. But
and even if there are specific instances we didn't talk about, and there are probably thousands, we've covered the different claims that can be used and the defenses and all the other things that you should do. Document before you come see us, right?
Absolutely.
So if I'm going to close on anything, I got to say, I enjoyed doing this series because, as we said in episode 1 of this series, neighbor disputes, in addition to failure to maintain, neighbor disputes are among the most common things that people come into our office for. That is to say, if you were to get rid of neighbor disputes, there would be a lot less litigation in California in HOAs, because it's a big chunk. And so it's a big topic. And it's not something we could have done in 1, 2, 3, or 4 episodes. No. We could have probably done it more completely in 10 episodes, but I thought 6 was a good number. We broke it up. I thought long and hard how to break it up, and I think 6 was a good number. So I hope everybody that's listening to this podcast has listened to the other 5, because you kind of need those to understand how this one fits into the whole tapestry. If you liked this episode or like this series on neighbor disputes, please hit the like button. And if you haven't already done so, I urge you to subscribe to our channel, HOA Hell. If you want to leave a comment, I would love to read it. And if you want to reach out to us, you can reach us at mbkchapman.com. Until next time, have a wonderful day.